how you doing?
I'm doing good, sir.
We've met before. I'm still Mike Sasso.
Yes, sir.
It's nice to see you.
I see you.
I'm going to have each of the commissioners introduce themselves to you.
Okay.
And then I'd like you to take a minute or so to give us some comments about yourself.
Okay.
And then we'll start with the questioning.
Okay.
And Andy Bartos will be asking you questions to start, and then the rest of us.
Okay.
Anyway,
Good morning, Your Honor. Vincent Citro from the Law Offices of Horowitz and Citro.
Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bartos with Gray Robinson.
I'm still Mike Sasso.
Brett Renton with Jefferson Bowen.
Good morning, Your Honor. Petra Brownlee, Brownlee Law Firm.
I'm David DeArmas from Kramer Price DeArmas in Orlando. Okay.
Your Honor, good to see you again. Scott Thomas with the Byrne Foreman Law Firm.
Okay. And you said just a minute, 1 minute?
Sure.
Okay, all right. Well, good morning.
I don't have your stuff much, so
Okay,
relax.
all right. Good morning. My name is Joe Boatwright. I'm a county court judge in Putnam County. I live in Putnam County with my wife Tammy, my 2 daughters Lauren and Kate, and my son Joshua. I'm applying for this position. I'm going to be an appellate judge. I think that my background, my diverse background, makes me qualified for this position. Academically, I have a bachelor's degree from the University of Florida, my law degree from the Catholic University, where I graduated second in my class, summa cum laude. Also was a member of the Catholic University Law Review. Also have an LLM in taxation from the University of Florida's Levin College of Law and an LLM in judicial studies from the Duke Law School. Prior to becoming a judge, I practiced out in the public and private sector for about 10 years as an assistant state attorney, also in private practice, representing government entities, representing the sheriff's office, supervisor of elections office in the city of Palatka, and also private citizens there in Putnam County. And after that, I managed the state attorney's office for 4 years for the current state attorney, which is RJ Larissa. Was elected to a judge. I've served in that capacity for 7 years. I'm a county court judge in Putnam County. I'm also an acting circuit judge, which I handle numerous circuit court matters. Also have an assignment on the circuit court docket, part of the family law docket, and have served in the past year as the administrative judge for the county, and we have 5 judges in the county. Also been privileged to sit on the 4th DCA as an associate judge and the 5th DCA as an associate judge. And not only have I practiced law for a number of years, but I've taught law at both the law school level and the state college level for about 15 years. So again, thank you for having me and giving me this opportunity to interview. If you have any questions, I'd be glad to answer those.
Good morning, Judge Boatwright. You mentioned sitting on the 4th DCA and the 5th DCA for some number of cases. Can you tell us more about that experience and what you might have learned or taken from those experiences, and how you think that might help you as a appellate judge?
Sure. Well, they were both great experiences. Obviously, it's a small sample size of dealing, when you deal with all the judges. So at the 5th DCA, I think I sat with had a handful of cases, had a lot more on the 4th DCA. So I think I learned, kind of the inner workings of the offices, how cases move through the office. 5th DCA, everything we did, for example, was every case we had an oral argument on. 4th DCA is different. They don't have oral arguments on every case. So I think 4 out of the 12 cases I think we handled went to oral arguments. On the 5th, well, at least I know the 2 judges I sat with on the 4th, there was much more an inclination to write. So I think even on cases that we did in reverse, we wrote on, and I wrote an opinion while there. But I think I didn't put it in my original application because it wasn't public at that time. And so I supplemented my application. I hope everybody got a copy of that. But that was an interesting process of just, writing the opinion, watching that go through the process. In the trial court, usually you write an opinion or an order and it's out. There you have to go through 2 judges, get them to approve, and then do the rest of the panel. But I mean, a really good experience. And I sat with Judge Levine and Judge Kuntz down there, and just incredible, both of them incredible judges.
You've also done a lot of writing, and as well as you getting 2 additional degrees since I think 2006 or so. How is it that you have the time, and I mean this in a complimentary way, how is it that you have the time to do all of that when going back to school for 2 LLMs and writing as much as you do? And what is it that drives you to do those additional things?
It's probably a personality, but I enjoy it. I would do it if I didn't enjoy it. Judge Leifman, well, I didn't write it with him, but Judge Leifman helped me down in Miami. He's pretty much a preeminent expert on mental illness and mental health in the court system. So by writing that article, we wrote about his program down there that has had national recognition at both the United States Supreme Court level and the Supreme Court level. The hope was that nationally, we try to get it put in a national publication, which got put in Georgetown's American Criminal Law Review, so that people throughout the country could see the program that he's running and hopefully help other people. So I mean, that was what I try to do, is so it's a contributing to the legal community.
And you also teach. Can you tell us about that experience and specifically what is your teaching philosophy or teaching style?
Well, I taught for about 10 years at Florida Coastal School in Jacksonville, teaching research and writing, a number of different tax classes, criminal procedure. Now that I have 3 small children, I don't go up there anymore. But I teach our state college business law 1 and 2. I don't know necessarily my teaching philosophy. It's just I want to make sure that I get my point across. And coming as an adjunct, I think I provide a lot of practical experience where a lot of the law professors don't practice anymore. So I'm able to provide a lot of practical experience for the students. So, and it's good you get to see your students. One of my students is now head of the state attorney's office, and so you get to see a lot of your students achieving throughout the legal system. I think it helps me a lot having taught, because a lot in county court you're dealing with a lot of young prosecutors and public defenders, and it gives you an appreciation to be able to work with them and have some patience with them.
And I'll ask one more question and then give the floor. Before you went to law school, you were principal of the school for 6 years.
Correct.
Okay. And so that's a pretty significant change and a decision then to go to law school. What brought about that change? Why did you decide to kind of shift gears and go to law school at that point?
Well, the school was a private parochial school, and we had a lot of issues with the school board at that time, not just our school, a lot of schools in the area. And we started to work with First Amendment legal groups and just got an interest for the law at that time. I had worked for a lawyer in Putnam County when I was in college, and so it's really, I went back to Catholic University. It was a school that focused on First Amendment and free exercise and Establishment Clause issues and religion and law. That's what I thought about doing, and I worked to be clerk to the American Center for Law and Justice, Jay Sekulo's group. So all those groups, once you got trial experience, I came back and got trial experience and just kind of ended up going this way, this route, instead of continuing that direction.
Great, thank you.
I was intrigued and really enjoyed your article on 501c3
Okay.
for political activity. I'm just going to ask you, if you've got a church where the pastor, doesn't matter if he's Democrat or Republican, just gets up in a pulpit on Sunday and says, you need to vote for so-and-so as president, and they hold fundraisers and do all that stuff on church property, do you think they should lose their 501c3 status? I'm putting you on the spot. Your article is very scholarly, so I want the author's opinion.
I think that's what the law is. I think my position in the article was, if you're going to, some groups get away with it, and then there's an example of a church there that they probably were very blatant. I think there's only been one occasion, and I put it in the article, where I haven't updated, where they've actually been stripped of that tax exempt status. So I think it goes on all the time. My point in the article was to make sure that if you're going to enforce that, enforce it fairly. And that was actually an issue that I had worked on in law school. I worked for American Center for Law and Justice. We were doing legislative work in the office at that time they were trying to get that changed, that political activity prohibition amended at that time.
Yeah, I just want to compliment you on, because I never thought about that issue. I mean, the article was very well written, and you did a wonderful job on that. I was intrigued by it.
All right, thank you.
I represent several churches. I was intrigued by the article, and I do care about it.
Tell them to cool it.
Yeah, it's just up, and the balance is very delicate.
Yes, sir.
I'm going to ask a question. If I understood you correctly, I think you said that the fourth DCA, in your experience, tends to write more opinions. Fifth DCA, I guess, goes to the PCA more often. Give me your thoughts on that.
that's a small sample size. You're
I understand,
working with-
but just generally speaking, your views.
Well, I read a Bar Journal article, I guess it was back with some 2016 statistics, which stated that the fifth, I think, was around 80% PCA. The fourth was around 70%, which seemed to probably play out. And, the time I sat on the fifth and the time I sat on the fourth. I think generally what I understand when you're looking to write an opinion at the appellate level is one of the main reasons is you're reversing and giving instruction below. Or you have a very complicated issue you want to write on. But I think when you're affirming, there's usually the inclination is not to write. And I just got the impression working with those two judges that they sought to write. I mean, we wrote, every case we wrote on, we had affirmed. Only one case we sent back was on a jurisdictional type issue. So I got the impression that they looked to write. But even in doing that, we still only wrote on about 30 or 40% of the cases. So we didn't write on the entire panel of the cases. I mean, some of them are just so clear cut that there's just not a reason to write on, or maybe just the facts or the way the case was, it just wasn't a good case to write on.
So taking that to the fifth DCA, if you are coming on the DCA, do you think the fifth DCA is about right at 80%? Do you think that it should be writing more opinions and giving one more explanation, or less?
Coming from the trial court, it's just a difference, because coming from the trial court, we're required to write on just about everything. I mean, we're required to at least give factual findings or conclusions of law. And so it's much different when you come and you're not required to do that. My inclination is to write just what I've done on the trial court, but I do understand there's times, there's clear-cut times when you're going to write, and then there's times when you probably aren't going to. I mean, if there's a clear-cut issue, let's say you're at a plea colloquy, and the plea colloquy is done perfectly, maybe there's not a reason to write on that. If the trial judge has done a perfect order, there's not a reason to write on that. Or somebody, at least and again, it's a small sample size, just on, a couple of appeals on the fourth and fifth, is somebody just basically trying to just relitigate their case. You've got a pro se and they're on a family law case, just trying to relitigate the facts, and maybe that's a reason not to write. But I'm inclined to write more, but I do understand there's pros and cons of writing and when you wouldn't write.
Thank you.
Your Honor, if I could follow up on that just a little bit. We tend to think, or at least maybe popular perception is there's sort of a progression from the trial bench to the appellate bench, but really they're very different skill sets in a lot of respects. What interests you in that move from the trial bench to the appellate bench, and where do we look to see how you best fill those different set of skills that an appellate judge has?
Well, having sat on the fourth and fifth, I mean, I probably had not thought about it until I got this opportunity to sit on, at least on the fifth, and it interested me, the work. I really enjoyed doing the work. I think academically, it's much more academically and intellectually challenging job. It's much more research oriented, and you get to sit back and really think about the cases, different on the trial level, that, oftentimes the issues are coming at you very fast. So I think those are things that interest me, and I think fit my skill set a lot better.
Judge, if I may, you talked about it being a different type of job and having several new challenges. So how many of your current commitments do you plan on keeping when you if you take the bench in the fifth?
Current commitments as?
You said you still teach out at the local college, you clearly write a lot. So if you forecast or see any change in sort of the other responsibilities that you would have voluntarily undertaken if you assume the position on the fifth?
No, I don't think so. I would probably not go back up and teach at Fort Coastal. I haven't been up there in a couple of years. I'm on a lot of nonprofit boards that probably takes up most of my free time. So maybe some of that would get cut back a little bit.
And can I ask you, with regard to writing and when it's appropriate to write, you mentioned providing instruction to the courts below. So I'm wondering if you can imagine a situation where, say that you're on the 5th District Court of Appeal and you're sitting on bunk to consider whether a prior precedent from this court should be overruled, so you need all the judges to decide. And when you're looking at the critical issue before the court, the debate starts flowing because there happens to be another issue that's obviously present in this case that you've seen several times before, but the court's never really addressed it. It wasn't briefed in this case, but you know from being in the community and seeing this issue arise that the courts below truly need instruction on this issue. Litigants need help, the attorneys need help. This is sort of an outstanding problem. You're all in the room sitting on bunk. No one briefed it. Can you talk a little bit about how you would handle addressing or not addressing it?
Also, an issue that might have come up, I think, on like the Grant versus Citizens Bank.
I'm not thinking of any
Okay.
one. I mean, I could sit here, we could talk about examples of it, but I wanted to know really how you would approach that situation.
I think you run into an issue, just like I think in that Citizens Bank case, where there's, there's some thought, at least from the dissent side, that are you able to just do an advisory opinion, and is that proper in that role to do an advisory opinion on something that wasn't briefed? And I think that's the issue.
Okay, so you would consider whether it's appropriate to do that. Do you think it would be appropriate to write if it wasn't brief? But again, they need instruction below.
I think it probably would, I would have to look on a case-by-case basis. My concern would be that you just be purely giving an advisory opinion on something that's not an issue before the court.
Gotcha. Can you also just briefly, I don't want to take up too much time, but with regard to the issue that was briefed and that would provide the reason for the court sitting on bunk, can you talk a little bit about how you approach stare decisis in the consideration of whether prior precedent should be overruled? Just like a quick, how you think you would approach a prior case that you think would potentially was wrongly decided.
Well, I
Certainly
think-
there's an argument for it.
I think stare decisis is important. Precedent is important to have some stability within the legal system. I think take for example, businesses count on that. They build their contracts on that. They build their businesses on that. So like a tier condo type situation where you're striking down part of the economic loss rule. So I think precedent is very important. Obviously, if there's a time to change the precedent, then I think it should be done. I mean, I wouldn't have a problem changing precedent if it needed to be done. So I'm thinking like a case like South Dakota versus Wayfair, which was a sales tax case at the United States Supreme Court level. At some point, it got to be where now you're dealing with a lot of online sales where you hadn't done that before, and so the minimum contacts, the physical presence test versus this minimum contacts test was changed, and it was time for a change. So I don't have a problem changing precedent, but I do believe that it's important to the stability of the legal system to try to follow it as much as possible. Obviously, at the level of the Fifth, you're required to follow all the decisions of the Florida Supreme Court, all the decisions of the United States Supreme Court on issues of constitutional law. You're not required to follow the other DCAs. So really what you're looking at is, you're inside the Fifth, and if, like you said, you'd have to sit, couldn't do it on a 3-judge panel, you'd have to sit en banc to do it. I think there's also other considerations is when you're getting ready to change that, are you causing conflict, with the other DCAs that may cause something to go up to the Florida Supreme Court level.
Thank you.
Okay?
Judge, it's clear that you are a scholar in terms of both writing samples, everything that you look at, and everything that's been to us. So I'm interested in getting your opinion. So congratulations, I'm going to appoint you, put
Okay.
together a Hall of Fame and a Hall of Shame in terms of best writings and worst writings in terms of opinions. Can you give me some examples of cases that you would put in the Hall of Fame and the Hall of Shame?
I usually follow, I like the DeBond case here in Florida. It's candidate opinion on statutory interpretation. That's an opinion that I use for interpreting statutes. I mean, it talks about going through an analysis for when you have an ambiguity. I would say maybe cases at the United States Supreme Court level, cases that I might disagree on would be something like King versus Burwell, where the courts talked about, I think the statutory language was creating state exchanges, and then the court just read into it, creating federal exchanges. Cases like Obergefell or Windsor, not on the merits per se, but just I'm not a big believer in creating rights out of the Fifth and 14th Amendment due process clause. So I would say those are, some opinions I agree with and some opinions that I disagree with. I don't want to call them Hall of Fame or Hall of Shame, but those are what I would agree or disagree with.
Thank you.
During your career, you ever come across an ethical dilemma that you had to work out? And what was the dilemma that you were confronted?
I think I get those quite often being in a small county. So I mean, you get calls from people that you know and call you about cases. And then, you know, it's especially when you're, you know, the small county that we're from. And so, you know, sometimes you have to hurt people's feelings when you tell them, hey, I can't talk to you about this case. And as soon as they start talking to you about it, then now you've got to recuse yourself. You know, I think those are probably the most that I face within the court system is that type of issue.
Yeah. I said, as soon as you tell them you can't talk, they just keep talking.
Yeah, I understand that, but let me tell you.
Let me tell you, it wasn't my son's fault. Anybody else? Yeah, I feel like I should apologize to all the candidates because the time period is so short, but we have 17, so.
That's fine.
I'm gonna wrap it up, and give you an opportunity to say anything, any closing remarks you'd like to make.
Thank you. Well, again, thank you for having me, and thank you for giving me this opportunity to interview with you. I hope you will consider my application and my diverse background, and considering giving me another opportunity to interview with the governor's office. So thank you.
Thank you.
Thank you for coming.
Thank you.